What's up, YouTube? It's your boy Maverick Raven, and today I've got a bit of a smile on my face, and as you can imagine, it must be in part thanks to this amazing news article that I'm about to read to you. It says the Supreme Court rules Trump to stay on ballot in a unanimous ruling. The High Court ruled that states cannot enforce Section 3 to remove a presidential candidate one day ahead of Super Tuesday. That's right. In case you've forgotten, Super Tuesday's tomorrow. We hope that Donald Trump wins, Super Tuesday bigly. He wins hugely. And after that, we hope that Nikki Haley would finally drop out, and we'll see if she goes on to become a spoiler for Donald Trump, which, God forbid. Oh, why am I making myself sad on such a momentously happy day? The Supreme Court ruled that former President Donald Trump cannot be removed from the ballot by individual states, overturning the Colorado Supreme Court decision that found him ineligible as a candidate and disqualified from the state ballot under Section 3 of the 14th Amendment. Responsibility for enforcing Section 3 against federal office holders and candidates rests with Congress and not the states. The judgment of the Colorado Supreme Court, therefore, cannot stand. The per curiam order reads, all 9 members of the court agree with that result. Now, this is where it starts to get a little stupid, a little bit of it does not make sense, and you'll see why. The order was issued today, March 4th, just a day before more than a dozen states hold their primary elections. President Trump reacted in a brief social media post. Big win for America. You damn right it is, Mr. President. You damn right it is. So they defer to Congress, and it says the Supreme Court ruled that states cannot enforce Section 3 for national candidates, but the Constitution empowers Congress to prescribe how those determinations to be made. I hope that that's not our judges that are writing that, and I hope it's an Epic Times typo. Section 5 of the 14th Amendment spells out Congress's authority to pass legislation to enforce the amendment, and the court opined that this power is critical when it comes to Section 3. States may only enforce Section 3 when it comes to state office, the opinion reads, in line with how states have historically used the statute. So here's the thing, right? The article is going to come up a little bit later, and it's gonna mention something that I've been harping on these last few days, which is presidents have a lot of things that they have to do, okay, and they affect obviously millions and millions of people just in this country alone. But then on top of that, because we are a superpower, it also affects the world at large. You cannot expect a president to be able to adequately do their job if they're going to be afraid that if they're a one-term president, or if that's the second term that they're, up to bat, that as soon as they're done with office altogether, that all of a sudden the next president, if it's from the opposing party, if the victor is from the opposing party, that he's going to come up and then go to prison or be held up on criminal charges just because a Democrat came after a Republican, as an example. You can't do that. And there's a reason why the framers made it this way, and that's one of the big reasons. You don't want a president who's afraid to act. The court noted a distinct lack of historical precedent where states use the statute to disqualify national candidates. As an initial matter, not even the respondents contend that the Constitution authorizes states to somehow remove sitting federal office holders who may be violating Section 3, the opinion reads, adding that this sort of power would flout constitutional principles. The justices found that the text of Section 3 itself reinforces this reading, as it allows Congress to remove a Section 3 disability through a 2/3 vote. The funny thing is that Justice Ketanji Brown Jackson was, I believe, the one that did this. But she asked a few days ago, a week ago, or what have you. She, I believe, is the one that asked, well, have has this ever been used before when the president hasn't even been, indicted on seditionist charges? He hasn't been indicted for inciting a rebellion or insurrection. So how are you even how do you even have, grounds for this? And ladies and gentlemen, the reason why they don't have grounds for this is because it's never been done. It was never meant to be done like this. And they're just trying to do whatever they can to get Donald Trump in a position where he cannot be president ever again. And they're hoping that Donald Trump will get his name tarnished, his legacy tarnished, to the point of where people won't vote for him. And that's what they're doing. Or at least that's what they're trying to do. The text imposes no limits on that power, and Congress may exercise it at any time, the opinion reads. In a footnote, now, this is where things start to get a little screwy. In a footnote, the court cited cases where Congress voted to remove this disability for members of Congress after the candidates had been elected. Experts who had predicted this ruling outcome had also warned of a potential last-minute disqualification in January. 4 Supreme Court justices noted their disagreement in opining on Congress's role in a presidential candidate disqualification. Justice Amy Coney Barrett wrote a separate concurring opinion that primarily stressed the unanimity of the court. The court has settled a politically charged issue in the volatile season of a presidential election, she wrote. Particularly in this circumstance, writings on the court should turn the national temperature down, not up. For present purposes, our differences are far less important than our unanimity. Excuse me. All 9 justices agree on the outcome of this case. That is the message Americans should take home. However, Justice Coney Barrett took issue with the part of the order that opined on the role of federal legislation in enforcing Section 3. Justices Sotomayor, Kagan, and Ketanji Brown Jackson likewise took issue with opining on federal legislation. They wrote another concurring order that even though all 9 members agreed Colorado could not enforce Section 3, the 3 justices thought the opinion should have ended there. Whatever. The majority is left with next to no support for its requirement that a Section 3 disqualification can occur only pursuant to legislation enacted for that purpose, the opinion reads. Oh, Lord. These people, I swear. Although only an individual state's actions is at issue here, the majority opines on which federal actors can enforce Section 3 and how they must do so, the opinion reads. In doing so, the majority shuts the door on other potential means of federal enforcement. We cannot join an opinion that decides momentous and difficult issues unnecessarily, and we therefore concur only in the judgment. Oh man, it'd be nice if the judicial system worked in such a way that they wouldn't make any type of legislation, what they call legislation from the bench, possible. But, it's just not going to happen. It's just, you know what? I shouldn't say that because I also thought that the Supreme Court was never going to strike Roe v. Wade. And they did awesomely. So, but anyways, there you have it, folks. President Trump won bigly, hugely again. And you know what that means. The left is in an absolute uproar. I'm going to go ahead and cover that probably a little bit later. But for now, be safe, be good to one another, and as always, stay based.